Hi, everyone. Welcome to the webinar. My name is Sarah Weeder, and I'm going to be acting as a host today. We are so lucky to have Yasmin here with us. She is an attorney for Johnson Law Group, and she is going to be talking about visitation rights for non-parent third parties. I'm sure there will be plenty of questions at the end of the webinar. So if you do have questions throughout the webinar, please type it into the Q&A box or the chat box at the bottom of your screen. At that point, at the end of the webinar, I will read out your questions to Yasmin and she will answer them accordingly. As always, your participation, registration, and questions are anonymous, and we are so happy to have you here with us today. So without further ado, I'm going to turn it over to Yasmin.
Thank you, Sarah. Good morning, everyone. As Sarah mentioned, I'm Yasmin. I'm an associate attorney with Johnson Law Group. First, I want to thank everyone who's watching this video either right now or later. We are really happy to have everyone participate and listen to this presentation. As Sarah mentioned, today I'm going to talk about visitation rights for non-parent third parties. And we are specifically going to address what's the law in Colorado, state of Colorado. So before I jump into more details, I'm going to basically address what this topic means. So sometimes we get calls from clients and they ask us what are our rights as non-parents as far as visitation wise with the kid or having any parenting time with the kids. Can we do anything about it if we were involved in the kids' life? And those parties can be different parties like grandparents, uncle, and like most of the times there are extended family members. And their answer is yes. Depends on the circumstances, but the answer is yes. There are different ways that we can get visitation rights or parenting time for a non-parent, or if a non-parent wants to provide, make sure they can get medical care for the kid or enroll them in the school. Like there are ways that a non-parent can do that. So we are basically going to talk about those issues. Before we move forward, I want to make sure to make that statement that this is not a legal advice, and attending this presentation does not create an attorney-client relationship. We just want to provide some presentation about these issues, but of course, if you have any specific questions or if you need to retain an attorney, you can definitely contact us, our firm, and we would be happy to help you. Okay, so first and foremost, the most important issue, what are the options for non-parent visitation and parenting time? Basically, there are a few options, and we're going to talk about the most common options in the state of Colorado for a non-parent. First is power of attorney. Second is guardianship. And third option is allocation of parental responsibilities. And last is grandparent visitation. So we are going to get into details about these four options one by one. First, I'm going to start with power of attorney. What is the power of attorney? And what's the legal authority or statute that covers power of attorney? The Colorado Revised Statute, section 15.14.105 governs the issue of power of attorney. And power of attorney is works in a situations that a parent or a guardian of a minor by a power of attorney may delegate to another person for a period non-exceeding 12 months any power regarding care, custody, or property of the minor, except they cannot give a power to that non-parent for them to consent to marriage or adoption of the kid. Do the parent and non-parent need to file the power of attorney with the court? The answer is no. Basically, it would be a legal contract between the parent and non-parent, that they sign it, they agree that the non-parent for a period not more than 12 months, not exceeding 1 year, can have provide care for the kid, or have the custody, or if the kid needs receive medical care, they can provide permission for that, or if the kid needs to be enrolled in school, the non-parent can provide that care and has the authority to do that task. So usually power of attorneys, because the duration of time is limited, it's not more than 1 year, it's on a temporary basis. So usually it's used when, let's say, in cases of, for instance, a child for any reason have moved in with his or her extended family, like grandparents, and let's say for a year he or she is going to live with the grandparents, and the grandparents need to enroll the kid in school. Like I said, the grandparents and the kid are living in a different state than the state that the parent lives. So by giving the power of attorney, the grandparents have the authority to enroll the kid in the school. Otherwise, the school won't let the non-parent to enroll the kid in the school. Or let's say that like if you consider the same situation, it happens that that minor child needs medical care. By giving the power of attorney to that family member, the family member is going to be able to get that medical care for the child without worrying that they need the consent from the parents, if the hospital needs to, or the school needs to contact the parent, of the difficulties they might face to be able to do those tasks. The power of attorney would help with make sure that those like small issues can be handled. But as I said, it's for a really short period of time. Sometimes parties can renew the power of attorney, but it should be like every 1 year. And again, does not need to be filed with the court. It's an agreement between the parties. Usually it's notarized, and so the parties would have a notary notarize the document, and they will keep that. And we always recommend the parties to keep a copy, keep the original one, and keep copy of the power of attorney. Second option is guardianship. Who is a guardian? Based on Colorado Revised Statute, Section 1514-201, guardian is an individual who is at least 21 years of age, resident or non-resident, who qualifies as a guardian of a minor. This statute says minor or incapacitated person, but this is really talking about minor children in this presentation. So I'm just going to focus on that part of the statute. Where can you file for guardianship? You usually have to file a petition for guardianship in a county that the minor resides in. So if the minor resides in Adams County, the person who wants to get guardianship should file a petition for guardianship in that county. If lives in another county, basically based on that change. And the guardianship is not necessarily permanent. It can be terminated. And can anyone ask for guardianship? The answer is no. There are different factors the court look into when a non-parent files a petition for guardianship to determine if it's proper that the court appoint a guardian for that minor. And the factors are if the parents have agreed that a non-parent can be the guardian of the minor child, or if the biological parents' parental rights have been terminated. What that means is sometimes there are cases their juvenile cases, and they're started by the state because one or both parents have been negligent. They call those dependency and neglect cases, and in those cases, sometimes the state petition that the court terminate the parents' parental rights because of what the parents have done that endanger the kids' safety and well-being. In those cases, if the court finds that, yeah, it's appropriate to terminate the parents' biological parents' parental rights, then they no longer have parental rights for the kids. And in that situation, of course, there's a need for an adult to be able to provide the care for the kid and have the custody. In those cases, yeah, it's appropriate for a guardian to be appointed for the child. The third factor is if the parents are unwilling or unable to exercise their parental rights. That means that if the parents come and say that, hey, you know what, I'm the biological father or mother of the kid, but I have no interest whatsoever to exercise my parenting time. I don't want my kid to live with me, which doesn't happen that often, but it happens. Happens if you have had cases that at least one of the parents they did not want to have responsibility toward the kid, either financially or providing care for the kids. They've never been in the picture since the kid was born. They have no interest. Or if they're unable to exercise their parental rights, and that means that if they're incarcerated, a person who's incarcerated does not have the ability to exercise his or her parenting time, or the parent that has died, of course, that parent unfortunately cannot exercise his or her parenting time anymore. And it's appropriate for the court to appoint a guardian. And the last factor the court will look into if guardianship of a child has been already or previously granted to a third party that was a non-parent, and that non-parent third party has died or become incapacitated to the point that they no longer can exercise the guardianship, and that person has not appointed another third party to be the guardian of the kid. In these cases, the court look into, okay, there was a guardian, that guardian no longer can exercise the guardianship, so we need to get another guardian for the child, for the minor child. And in those cases, the court is not going to presume that it's in the best interest of the child that the child would be in care of their biological parent, because the court already determined that's better for the kid to be in the care of the guardian. And because of that, the court would, if another guardian wants to resume that guardianship, then the court would consider that. So briefly, to just say, not everyone can ask for a guardianship. So one of these circumstances should be there for the person to be qualified as a guardian. You can file a petition for guardianship, but the court will look into, you have to provide the facts that I want to be the guardian because the parents agreed, I want to be a guardian because the parents, biological parents, parental rights have been terminated. I want to be the parent because the parents are unwilling or unable to exercise parental rights, or there was another guardian that no longer can exercise the guardianship. Otherwise, the court would basically deny the petition for guardianship. So now we're going to talk about what are the duties and powers of the guardian. So we're going to first start with the duties of a guardian. The guardian should make himself or herself aware of the needs of the minor child, so they can provide the care that the the minor child needs. So we can just be guardianship and say that, you know what, I mean, I'm just a guardianship, I'm not the parent, so I'm not going to look into what the kids, what the child's needs are. That's not how it works. As a guardian, you're going to have some duties and responsibilities toward the kids. And if the kid has any properties, the guardian's duty is to protect that property. If the minor child is receiving any benefits or funds, the guardian needs to make sure that they're taking control of that, because as a minor child, the child cannot do that, and make sure that spending those funds and benefits for the interest of the child, for the child needs, like if they need to pay for the child's school or medical care or anything that basically are the child needs, the guardian needs to make sure those funds are used for the child's needs. And usually the court requires guardians to file status reports with the court once in a while. So to report the court about the condition of the minor child, if there are any assets or monies or funds of the child that are in the possession of the guardians, and how those are being spent. And of course, the guardian should keep informing the court about their address, like if they have changed their address or anything, or if the minor child has changed their address, they have to provide an update to the court. And second, we're going to talk about the powers of the guardian, what the guardian can do when they are appointed as a guardian. The guardian can apply for benefits on behalf of the minor child. They can be benefits that a child can receive from government, that can be basically any benefits they can be qualified for. They have the authority to do that on behalf of the child. If they need insurance, so basically make sure, again, that goes back to what we talked in the previous slide about what are the duties of the guardian, is like that kind of the powers of the guardian and the duties of the guardian are kind of aligned, because the statute gives guardians some power so they can provide the care that the child needs. That's why they need to be aware of the child's needs. If it is consistent, the terms of the court order, the guardian can have the custody of the child. If there's need for medical care or treatment, the guardian can provide his or her consent for that medical care or treatment. The guardian can consent to the marriage of the minor child if the minor child wants to get married. Basically, this statute requires the consent of a biological parent, but since in this case the biological parent is not basically participating in his or her parental responsibilities, the guardian on behalf of the parent can provide the consent for the minor child's marriage. And we kind of touch base on that issue. Can the guardianship be terminated? The answer is yes. Guardianship can terminate upon the minor's death. If the minor get adopted by another family or parents, the guardianship would terminate it, because in that case, the minor child going to have parents who is going to start exercising their parental responsibilities, or emancipation of the minor child, or if the child reaches the age of 18 or more. In that case, they're no longer considered minor, and the court would terminate the guardianship. And also if the court orders termination of the guardianship, and that can be like different circumstances why the court would order termination of the guardianship. If a parent's petition that the court terminates the guardianship, the court can look into that. Where was the parent before? Why now they want the guardianship to be terminated? Like, let's say if someone got a guardianship because the parent was incarcerated, when the parent is out of prison or jail, they can petition the court to terminate the guardianship, because back then when the guardian got appointed, that parent was not able to exercise his or her parental rights. But now they've been released from prison, and now they are able to resume their parental responsibilities or parental rights. So like, that was just one example. Or the court finds that, you know, the guardian is not really acting in the best interest of the child, and that's why it's appropriate to terminate the guardian's guardianship. That's why the court asks for status reports from the guardian once in a while. And these are just two examples of like how the court can terminate the guardianship appointment. What are the pros and cons of guardianship? Is it a good idea to file a petition for guardianship? How helpful it is? Well, that kind of depends on what are the goals a non-parent try to achieve by filing a petition for guardianship. So basically, guardianship is the lowest level of parental rights afforded to third parties. It's kind of similar to power of attorney. The duration of time might be longer than power of attorney, because as we discussed, the power of attorney usually lasts for 1 year unless you extend it. Guardianships can be longer if it won't be terminated. So you will have that guardianship appointment possibly for longer than power of attorney, but they kind of similar. And also relatively it's a quicker and easier process to get a guardianship, especially if there's no parent to provide care for the child. Let's say the parents have passed away, or they're both incarcerated, or they're both unwilling to provide the care and take custody of the child. The guardianship can file a petition for emergency guardianship, so we get emergency petition. So because there is no one to basically take care of the child, and the child needs an adult to make sure that all their needs are being met, someone to take custody of them. So that's why we say that it's relatively a quicker process compared to the other options that you're going to discuss in the next slides. It, as I said, it depends on what the non-parent's goals are as far as filing the petition for guardianship. Guardianship works well to accomplish small goals, like if as I said, like the example that I used for the power of attorney, it kind of applies here. So if the minor child has been living with the grandparents, let's say for a while, and they're in a different state, the grandparent can enroll, like as a guardian, they can enroll the kids or the kid in the school. They can receive medical treatment and make sure that the child receives medical treatment, or they need to enroll them in any extracurricular activities, after school activities. They can do that with no problem. They can just show the school or the hospital or the physician the court order appointing them as a guardian, and make sure that they can do like those enrollments and receiving medical care for the child on their behalf with no problem. Guardians do not grant really any parental rights to the guardian over the biological or adoptive parents. As you remember, we discussed that in the previous slide, that the court can terminate the guardianship. Just because someone is a guardian, that doesn't mean that it's permanent. That means that, you know, the court is going to terminate the biological parent's parental rights. So if if the guardianship was granted because the biological parents were not able or unwilling to exercise their parental rights, that doesn't mean that the parental rights have been terminated. But appointing guardian, they can come back at any point and say, you know, I was unable to exercise my parental rights before, but now, you know, I'm here and I'm able and willing to do that. So the court is not going to say that, hey, no, we already appointed the guardian, so you have no rights whatsoever. And also, if the child, if another family adopts the child, then those adoptive parents basically would be like the biological parents, and they have like the parental rights. So the guardian does not have those parental rights over, like, so they're like, they want to make sure that the guardian has not more rights over the biological parents. As we said, the guardianship can be taken away at any time, and that's why I mentioned that although it's not as short as power of attorney, the duration, it can be longer, but that doesn't mean that's permanent. The court can terminate it. The biological parents can petition to terminate the guardianship, and then the guardianship does not necessarily permit the guardian visitation rights. So that's something that the court can order it, but it's not required. So those are, so it really depends on what non-parents try to achieve from asking for a guardianship. It's in some cases, in the example, like I mentioned, that if the child's parents have passed away or they're incarcerated, at the same time there's no parents to provide care and get custody of the kids, in those cases might be appropriate to file an emergency petition for guardianship, because that needs to be done as soon as possible. And if that would be filed as an emergency motion, the court would notice and then try to address it as soon as possible, compared to allocation of parental responsibilities that we're going to talk in the next slides. So in that case, it's appropriate. It can be changed, the guardianship, to allocation of parental responsibilities. There are specific circumstances around that, but it depends on what non-parents want to achieve. But it's not really a long-term permanent right that cannot be terminated or cannot be taken away. So non-parents should keep that in mind when they are asking for guardianship. Next, we're going to talk about grandparent visitation. What we're talking about when we're talking about grandparent visitation, as the name is on it, it specifically applies to grandparents. So you're not talking about other extended family members like uncles, cousins, and you're just talking about grandparents. That's like the statute is really specific, that just applies to the grandparents. So the statute that covers the issue of grandparent visitation is Colorado Revised Statute, section 19-117. That statute says that any grandparent or great grandparent of a child may seek a court order granting the grandparent or great grandparent reasonable visitation rights when there is or has been a child custody case or case concerning the allocation of parental responsibilities relating to the child. So we would talk about what that means, the last section of the statute. But as I said, grandparents and great-grandparents, they can ask for visitation. And we're just talking about visitation, not parental rights or responsibilities. Visitation is different from custody. Visitation usually means like, you know, like once a week, few times a month, you can go see your grandkids. That doesn't mean that you have a custody of the kids. The biological parents still would maintain their custody of the kids, and they still maintain their right to exercise their parental responsibilities. So we're merely talking about visitation that the grandparents can have with the child or children. And again, we're talking about Colorado, so that's like every state is different as how they do the grandparent visitations. But Colorado has the statute that basically grants that right to the grandparent that they can ask for a grandparent visitation. Does that mean that every time they ask for it, it would be granted? No, but at least they have the option to ask for that per the statute. As I mentioned, the second part of the statute talked about like a grandparent or a great grandparent can ask for a visitation. However, at the end it says that if there is a case, allocation of parental responsibility case is pending, or basically kind of listed like a number of ways that you can ask for a grandparent visitation. So we're going to talk about that right now. So the statute said if there's a case concerning allocation of parental responsibilities, and what that means is, let's say if there is a pending case for dissolution of marriage, for divorce, the parents have filed for divorce, and there's a case pending with the court, the grandparent can file a petition for a grandparent visitation in that case. So they don't need to open a new case. They cannot open a new case when there's a case pending. They just need to file a petition within the same case with the same court. Or if there is a case regarding allocation of parental responsibilities. What's the difference between allocation of parental responsibilities case and a divorce case? In divorce case, of course, everyone knows the parents in those situations, they've been married, now they want to get divorced, they file a divorce case, the court is going to address the issue of parental responsibilities. For allocation of parental responsibilities cases, the parents were never married, but now either they're separated or they've been separated, they just never addressed who is going to have what kind of parenting time with the kid, and now they want the court to address it, or they just separated, so they don't know what to do, they cannot reach an agreement, so they file that petition for allocation of parental responsibilities. The grandparent, like similar to the divorce case, the grandparent needs to file the petition for grandparent visitation within the case in which the allocation of parental responsibility is pending with the same court, so they don't need to open a new case. However, if there is no case pending, which happens, that there's no divorce case pending, there is no allocation of parental responsibility case pending, and let's say that the child's parent or parents have passed away, the grandparent can open a new case. In Colorado, usually they open that as a juvenile case with the juvenile court. So basically they open a new case because there's no case pending that they can file their petition within that case, so they need to open a new case. So these kind of cases are somewhat difficult, and the reason is not because if the issues are complex or what does the statute says. Usually they're difficult because it's really emotional, because basically it's a battle between a biological parent and a grandparent. The parent says that I no longer want you to see my kids. The grandparent wants to see the kids. So that's why it makes it somewhat difficult, because it gets really emotional, because the biological parents, they believe that they know what's better for the kids, what's in the best interest of the kids, and at the same time the grandparents want to have that visitation with the grandkids. It happens a lot that when one of the parents dies, the grandparent, let's say if the father has passed away, the paternal grandparents wants to have visitation if mother is not allowing the grandparents to see the kids, or vice versa, if mother has passed away, the maternal grandparents. So it happens a lot when one of the parents has passed away, and since like they have passed away, the grandparents could not see the kids, so that's why they're filing a petition for grandparent visitation. Where do grandparents need to file a petition for a grandparent visitation? Basically, they need to file a petition in a county that the child resides. So if the child resides in Denver County with his or her parents, the petition for grandparent visitation need to be filed in that case, if there's no case pending again. If there's already a divorce case or allocation of parental responsibility case pending, then the grandparent has to file the petition in that case, which usually the divorce cases or allocation of parental responsibility cases are filed in the county that the parties live, and usually the kids live with the parties or one of them, so that wouldn't be an issue when there's a case pending. So now sometimes my clients ask me if the court grants the grandparents' request for grandparent visitation, can me and my child move out of state or not? The answer is kind of yes, because per the statute, the court may not make any order restricting the movement of a child. If that restriction is imposed only for the purpose of allowing the grandparent or great-grandparent to exercise their visitation rights with the child. And that's how it makes it, it's another factor that makes grandparent visitation different from biological parents' right to exercise parental responsibilities. For cases that involve biological parents, and we're talking about parental responsibilities, neither parent can move out of state without the agreement of the other parent or permission of the court. They usually have to file a motion to relocate. But in those cases, since grandparents or great-grandparents are only receiving visitation, not custody of the kid, the court cannot restrict the child from moving out of state. So is it easy to get grandparent visitation? Does the court just say that you filed for a petition for grandparent visitation, I'm going to grant it? No. There's a specific standard that the court has to rely on that standard to determine if it's appropriate to grant the grandparents' request for visitation. So there is a presumption in favor of the biological parent regarding the determination of what's in the best interest of the child. So basically that means that if the parent believes that it's not in the best interest of his or her kid that they have a visitation with the grandparents, then the court, based on the statute and the case law, they have to give them that presumption in their favor that, yeah, as a biological parent, they're making the decisions just in the best interest of the kid. So we have that presumption. But the court would grant the grandparent or great-grandparent an opportunity to rebut that presumption, to rebut that by clear and convincing evidence that the parent's decision that grandparents should not have visitation with the kids is not in the best interest of the kid. or if we can show that the parent is an unfit parent and they cannot make decision that's in the best interest of the child. So basically, the burden of the proof is on the grandparents and the great grandparents to show that the decision that the parent is making is not in the kid's best interest. It's in their best interest, and it's in the kid's best interest that they have visitation with the grandparents. And how that can be proven under different ways. The grandparents usually would show that they had a close relationship with the grandkids, had a bond, they were seeing each other often. Again, as I said, that these kind of cases happen often when one of the parents has passed away. So sometimes grandparents try to show that before my son or my daughter died, I was seeing my grandkids every week. We'll go on vacation together, providing childcare for the grandkids when the parents need it. And all of a sudden, I cannot see the parent, I cannot see the kids, and I don't think it's in their best interest. My child has passed away, so I want to make sure we are continuing their relationship with my grandkids, or the parent is doing something that is not making a decision or acting in a way that's not in the best interest of the child, like they have acted in a manner or made this decision that has endangered the kids, or keeping the grandkids from the grandparents is not good for them, like mentally, physically, because they always had that bond. The kids keep asking about the grandparents. So basically, they have to prove all those numerous factors to be able to rebut that presumption. And last, we're going to talk about allocation of parental responsibilities. So I kind of mentioned that term before about allocation of parental responsibilities. Allocation of parental responsibilities basically is like a parent who has the power to exercise parental rights and has some duties toward the kids as a biological parent. So basically, by asking for allocation of parental responsibilities as a non-parent, the non-parent is going to act like a parent. Basically, they're going to be given the same power and duty as a biological parent. So that's what it makes it different from power of attorney, from a guardianship, from a grandparent visitation. So basically, you would be like a parent. You can exercise parenting time with the kids. You can exercise decision making for the kids. So all would be like same as a biological parent. And the question is, who can file a petition for allocation of parental responsibility? So as a non-parent, any non-parent who has a present physical care of the child can file a petition for allocation of parental responsibilities. So let's say if the kids have been living with the uncle and the parents were not living with them, the kids alone were living with the uncle, and the uncle was providing care for them, that uncle can file a petition for allocation of parental responsibilities. But there's like a time frame for that, so there's a requirement. So the kid should have been living or should have been in the care of that non-parent for the last 182 days. It's a bit over 6 months, basically. Or the non-parent who had the physical care of the child for at least 182 days, so long as the action for allocation of parental responsibilities is filed within 182 days after the non-parent's physical care terminated. So that means that the uncle had the kid for 182 days, but then something happened and the kids were removed from his care, and but it has not been yet 182 days passed since his physical care of the kids have terminated. In that case, he can still file a petition for allocation of parental responsibilities. So it's important to keep that time frame in mind, because that's really important. Because if it passes that time frame, the deadline, if you file a non-parent file a petition for allocation of parental responsibilities and someone objects to it, or the court finds that the kids have not been quarantined, they're not in the physical care of the non-parent, or they have not been in the care of the non-parent for the last 182 days, that 182 days has already passed, they would deny their petition for allocation of parental responsibilities. Or as I said, there are some cases that the basically Department of Human Services the state stars as a dependency and neglect cases, call them D&N cases. So just abbreviation for dependency and neglect. In those cases, sometimes, as I mentioned, sometimes the court terminates the parental responsibility of the child, and then grant the custody to a non-parent, mostly like to an extended family, grandparents, uncle, aunts. And then in those cases, the non-parent can open an APR case, or there have been some cases that are encountered that the case starts as a dependency and neglect as a juvenile case. The court does not terminate the parents' parental rights, but they give custody of the kids to the extended family. And they say that, okay, if you want to ask for allocation of parental responsibilities, you have to file a case with the domestic relations court. So those are different. Juvenile courts are different from domestic relation courts. So in that cases, or they say that I've seen in some cases that the court itself, the juvenile court itself, consolidate the cases, basically register the court order in the juvenile case into a domestic relation court case, and then the non-parent can take it from there. Or the parent wants to come back and ask for modification, they have to go through the domestic relation cases. So as I kind of briefly mentioned, when you get allocation of parental responsibilities as a non-parent, basically that allows a non-parent to step into the shoes of a parent, and they will be allocated decision-making responsibilities and parenting time rights over a child. That means that the non-parent can make decisions about the child, about their education, medical care, about enrolling them in after school activities. Basically, any decision needs to be made for the child. These are just the major decisions, and they can have parenting time rights. So that's not visitation. That's like parenting time rights. That means that the kid would be in custody of that non-parent, and if the biological parent wants to modify that, they have to ask for a modification, because in that case, in the allocation of parental responsibility, basically the court says, but granting that, court says that, okay, non-parent, I know that you're not a biological parent, but since you have proved that we can grant your petition for allocation of parental responsibilities, you're going to be basically act like a parent, and but that means that you're not only going to have the powers of a biological parent, you have the same duties like a biological parent. So in that case, the biological parents have to ask for modification. And we talked about that allocation of parental responsibilities can be filed. The petition can be filed by a non-parent who has the child in the physical care. And what is physical care? So the case law states that the physical care does not need to be exclusive or uninterrupted. So that mean that, okay, you always had the kid with yourself. No one ever, came to help with care of the child, or the parents were gone for like the entire time. But what the court look into is the nature of that physical care, the duration of the contact between the non-parent and the child, and the frequency. What that means that, let's say, if the grandparents are providing childcare for them, for the child, and they're receiving direction from the parents, that's not really considered like that they have physical care of the child, because in those situations, basically, they're just like a babysitter that provide childcare. Like the kids, the parents would drop off the kids at the grandparents' house, and then for a few hours or the entire day they're there with the grandparents, and they come pick the kids up, or they the parents tell the grandparents like what to do, what not to do, as far as when it comes to providing care for the kids when the kids are with the grandparents. In those situations, they don't really have a physical care of the kids. They're just acting like a childcare provider, or they're receiving direction from the parents. Physical care mostly means that you have, not only you have the kids are like staying with you, you basically have you are independent on like how to provide care for the child. You're not receiving direction from the parents are not really involved. So that's the court will look into that as well, because in some situations we've seen that both the child and the parents have been living with that non-parent. Again, most of the times that applies to extended family members. And but the parent, maybe he or she is not home during the day because they were at work or something, but when they would come back home, they would provide the care for the child. They would make food for them, they would feed them, they would help them with their homework, stuff like that. And or they were telling them, the non-parent, that while I'm at work, please do that. That's what kind of food you have to give to my kid. Like help them with those homeworks. Like the giving direction to the non-parent. So in those cases, basically, it's there's not really physical care of the kid, and basically physical care of the kid with the non-parent. So basically, the non-parent needs to prove that they had a physical care. But the non-parent does not have to prove that the child is more bonded to the non-parent than the parent. So because sometimes parents come back and say that, oh, but like he or she is my kid, so we are more bonded. Yes, that happens, because it's normal that the child would have most cases have more bonded relationship with the biological parents. But in instances where basically the biological parent left the kid with the non-parent for a duration of time, like 6 months or more, that non-parent was the one that providing care for the child. And there's no requirement that the non-parent should show that they have more bond compared to the relationship of the parent with the child. And last question, where a non-parent should file a petition for allocation of parental responsibilities? The answer is kind of the same as guardianship and visitation for grandparents. Petition should be filed in a county where the child is located, basically where the child resides. So that's really easy to determine what county the child is living in. So yeah, that was basically the presentation today. Thank you so much for attending and listening. I guess now it's time for questions, if anyone has any questions for me.
Thank you so much, Yasmin. So as she mentioned, if you guys have any questions, please feel free to type them into the chat box or the Q&A box. And while you guys do that, just a reminder that we do have another upcoming webinar with Yasmin next week. You will receive a link to that in your follow-up email coming after this webinar. You can also stay up to date on all of our past and future webinars by following us on YouTube and following us on our other social media platforms, Facebook, LinkedIn, Instagram. And if you have any questions that you think of after the webinar, feel free to email us at info@johnsonlgroup.com, and we will happily answer your questions, or you can feel free to give us a call anytime. If you want to speak to Yasmin specifically, we can easily put you in contact with her directly. So feel free to reach out at any time. So I'm not seeing any questions. I know that Yasmin's webinar was incredibly specific and detailed, so I'm thinking that she probably covered a lot of things. But as I mentioned, if you guys do have any questions after this webinar, today, tomorrow, 3 weeks from now, feel free to reach out, let us know. We are happy to help you any way that we possibly can. And we really appreciate you attending and listening to this webinar. We hope to see you at the next one. Thank you, Yasmin.
Thank you, Sarah.